Good afternoon, everyone, and thanks for joining us for a Tax Practitioners Board webinar. My name's Julie Shaw, and I'll be hosting today's session. In the spirit of reconciliation, we respectfully acknowledge the traditional owners and custodians of country throughout Australia and their connections to land, sea, and community. We pay our respect to their cultures and elders, past, present, and emerging. Now, just to begin today's session, I've got a couple of quick housekeeping messages. First of all, to access today's slides, you can visit our webinar resources hub, and you can find that at tpb.gov.au/webinar-hub. You also see the link to that on the slide. We'll also email you a copy of the slides following today's presentation, and today's webinar does count towards your continuing professional education or CPE, and you can claim 1 hour for attending today's webinar. And just in relation to claiming your CPE, we are now issuing attendance certificates to those of you that are staying online for the webinar. So the attendance certificates are issued in an email, and they will come to you roughly a couple of days after the webinar, and we'll use the email address that you have used to register for the webinar to send out the certificates. But a good point to note is that if you're a registered tax practitioner, when you do register for one of the webinars, just be sure to use your TPB My Profile email address. That just makes it a little bit easier and quicker to get your certificates. So let's now take a quick look at what we're going to be covering off on today. So in today's webinar, we'll discuss who must satisfy the fit and proper requirement. We'll look at professional conduct of tax practitioners. We'll also talk about the criteria to determine fitness and propriety. We'll have a look at events that can affect your fitness and propriety, how we assess fitness and propriety, and also the consequences for no longer being a fit and proper person. We're also going to look at some case studies, and then finally at the end of the webinar today we'll answer some of the common questions we received during the session. And in that regard, we've got two of our policy and legislation team members joining us. That's Fiona and Daniel, and they'll be online today to respond to the questions as we go. So just make sure you put those through in the chat box there. So now I'd like to introduce our speaker for today, TPB board member Deborah Anderson. Now Deborah's a registered tax practitioner, and she has extensive experience as a BAS agent and a tax agent, and so she'll be able to offer you some great advice today. So thank you, Deborah, for joining us, and I'll hand over to you now to kick off the presentation.
Thank you, Julian, and thank you for everyone for joining us today. It's the first one I've done for this year. It feels like forever since I've done a webinar, but I've just had a quick look in the participants panel, and so great to see so many of you here today with us, many familiar names in the participant panel today, so hi. Also, hope you had a great break. I know it's been a really tough few years with the COVID and, you know, all of that kind of stuff. So I hope you took the opportunity to have a bit of a break and recharge, ready for another big year. So today's focus is about helping you to understand what the TPB's fit and proper person requirements are. They are contained in the Tax Agent Services Act 2009, or the TASA, I'll call it TASA for short. So, you know, it is something that overrides every single thing that we do as tax practitioners. And of course, when I say tax practitioners, I'm referring to both tax and BAS agents. Tax practitioners, again, is that umbrella term for both the BAS agent and tax agent population. So before we go into the fit and proper assessment criteria, we should know who these requirements actually apply to. So we're going to do a quick poll to see who must satisfy the fit and proper requirement. Now, it's a multiple choice question, so please select your response from the options provided. And the question is, who must satisfy the fit and proper requirement in the TASA? So you have the following options. You've got individual tax agents, you've got directors of a company tax practitioner, directors of a company partner or of a partnership tax practitioner, and individual partners of a partnership tax practitioner. So there's a bit of a mouthful there, but Please select which one. I will give you a hint though, there is more than one correct answer. So yeah, have a look at that. And when selecting your response, assume all the options provided include those applying to register or who already are registered tax practitioners. So let's go and have a look at this poll, shall we? How long are we leaving the poll open for, Julie?
Yeah, it looks like we've got about 37% of people responded so far. So we'll keep it open for a couple more seconds. So if you want to participate, just pop your answers through. And I will note that if you can't see the slide automatically pop up, there's also an orange icon up the top of your screen that you can click on, which will open the poll as well. So that should fix any issues that you're having. Because sometimes if you've got security on your computer, it doesn't recognise the poll, so it won't open up. Okay, so we might close that off and we'll just share those results on the screen. So Deborah, hopefully you can see those and I'll hand back to you so you can go through that.
I can, and I did try and give you a hint in that there was more than one, because the answer is actually all of them. So all individuals must satisfy our fit and proper person requirement to be registered as a tax or a BAS agent with TPB. And importantly, not only must you be a fit and proper person when you apply, but you must continue to be a fit and proper person to remain registered with us, as it is an ongoing registration requirement. In the case of a company, every director of the company needs to satisfy the fit and proper person requirements, regardless of whether that director is a registered tax practitioner or not. So every director in a company, and likewise in the case of a partnership, every partner needs to be a fit and proper person. Or if we've got a company as a partner, the company's directors all need to be fit and proper people. So you can see sometimes it's multi-level, but really important that, we always make sure that the individuals behind the entity are fit and proper people. So to understand the concept of fitness and propriety for tax practitioners, we need to first understand what the expected professional conduct of a tax practitioner is. And so we'll look at that now. By using the term professional conduct, we mean the way in which you act in your professional capacity. So you play such an important role in providing services to the community, which include a wide range of clients, those involved in business, professionals, and also individuals with little or no knowledge whatsoever of our tax system. So it's an important role that demands attributes such as competence, good fame, integrity, and character. So your conduct should be such that the TPB or the ATO and the public can have the trust and confidence that you will perform your role competently and importantly with integrity. When providing services to clients, it's expected that you will display an appropriate professional standard of behaviour that goes beyond someone who is not a professional or not acting in a professional capacity. And this professional conduct should go beyond just your relationship with your clients. It needs to extend to your relationship with the ATO, the TPB, and other regulatory bodies as well. So I'll elaborate what is expected in those relationships a little later on. But here I'd like to point out that matters that affect fitness and propriety may also be relevant in finding a breach of the Code of Professional Conduct, or what we call the Code, under one of the civil penalty provisions in the TASA. So let's do a really quick recap of the Code and the civil penalty provisions. As you know, the Code establishes a set of ethical and professional standards for all tax practitioners. We're not going to go into the details of the Code in this particular webinar, but the slide does provide a list of the 14 Code items. And the 14 core principles in the code are grouped under 5 categories. So we've got honesty and integrity, independence, confidentiality, competence, and the good old other responsibilities as well. While the code applies only to registered tax practitioners, we can use the civil penalty provisions in the TASA to address certain conduct of unregistered persons or unregistered entities, as well as registered tax practitioners. So for a breach of any civil penalty provision, we can apply to the federal court for a civil penalty order against the person or against the entity that breached the provision. And we can also apply to the federal court for an injunction to restrain or enforce conduct, where there is a finding that a certain conduct by a person or an entity would breach a civil penalty provision. So now let's jump in and look at the criteria set out in the TASA on what the TPB must consider in determining whether it is satisfied that an individual is a fit and proper person for the purposes of registration with the TPB. The TASA states that to be satisfied that an individual is a fit and proper person for the purposes of registration as a tax practitioner, the TPB must consider the following: whether the individual is of good fame, integrity and character, whether an event described in section 20-45 of the TASA has occurred in the previous 5 years, and I'll look at those events on the next slide, whether the individual has had a status of an undischarged bankrupt at any time during the previous 5 years, and whether the individual served a term of imprisonment in whole or in part at any time during the previous 5 years. So you can see there's, quite a few different elements to this, but let's go and have a look now at what the events described in section 20-45 in the TASA are. And these are the events that could affect the continued registration of a tax practitioner. And they are: if you've been convicted of a serious taxation offence, if you are convicted of an offence involving fraud or dishonesty, if you are penalised for being a promoter of a tax exploitation scheme, sorry about that, or if you are penalised for implementing a scheme that has been promoted on the basis of conformity with a product ruling in a way that is materially different to that described in the product ruling, if you become an undischarged bankrupt or go into external administration, or if you are sentenced to a term of imprisonment. So let's go and deep dive further into seeing what each of these offences or events can mean. Some of these are defined in the TASA and others aren't. So if they're not, they take on their ordinary meaning. So if we have a look at the first event, it's a serious taxation offence. And the TASA defines a serious taxation offence as an offence specified in the Criminal Code if it relates to a tax liability, or a taxation offence that is punishable by a fine exceeding 40 penalty points or imprisonment, or both. Event number 2 was an offence involving fraud or dishonesty, and an offence involving fraud or dishonesty is not defined in the TASA, so it takes on its ordinary meaning and is determined by reference to community standards. So, for example, the Criminal Code, which is an act or legislation of Parliament, defines dishonest as dishonest according to the standards of ordinary people in circumstances where the defendant is aware of those standards. Events 3 and 4 penalised for a tax exploitation scheme. So Division 290 of Schedule 1 to the Tax Administration Act 1953 defines conduct that is considered to be a promoter of a tax exploitation scheme, and implementing a scheme that is materially different to that is what is prescribed in the relevant product ruling. The ATO has released a law administration practice statement, PSLA 2021-1, which provides guidance on the application of Division 290, and we'll share a link to this ATO guidance in our hyperlinks document, which will be emailed to you after this session by Julie. We will consider that an individual or an entity is a promoter of a tax exploitation scheme or implemented a scheme if they have been ordered to pay a civil penalty by the federal court for engaging in such conduct. Event 5 is the undischarged bankrupt or under external administration, and a tax practitioner will be considered an undischarged bankrupt when they have been declared bankrupt under the Bankruptcy Act 1966 and they have not been discharged from the bankruptcy. I'll discuss the range of factors that we would consider when assessing fitness and propriety when an individual becomes an undischarged bankrupt a little later in the session today, as there's quite a few considerations there. And you're also declared bankrupt if a company goes into external administration. So it goes into external administration as defined in the Corporations Act 2001. And this generally means that its directors are required to hand over direction of the company's affairs to a receiver or an administrator, provisional liquidator, or a liquidator. And event 6 is if the practitioner has been sentenced to a term of imprisonment, and that's our final event. So as the term suggests, an individual is considered to be sentenced to a term of imprisonment if the sentence is imposed on the individual, and that sentence includes a term of imprisonment. To be sentenced, the individual need not have actually served any part of the term of imprisonment. And by that we mean, like, for example, a suspended sentence. And it is sufficient that the court has imposed a sentence on the individual for us to consider that this event has actually occurred. So now that we've looked at all the various events that can affect your fitness and propriety, let's see what the reporting obligations are regarding that. So new applicants for a tax agent or a BAS agent registration need to disclose any of these events that we've just discussed in their registration application form, providing details and circumstances of the events. So what do you think those practitioners already registered as a tax agent or BAS agent should do when one of these events occurs to them, or if one of these events occurs to them, I should say? Let's do a quick poll now before we discuss that further. Julie, I'll get you to run this poll if you don't mind.
Yeah, of course. Thanks, Deborah. So this poll here, the question that we're asking you is, if you are a registered tax or BAS agent, what should you do if an event affecting your registration occurs? And the options that we have for you are A, notify the TPB of the event details in writing within 30 days of the event occurring. Option B, disclose the event details to the TPB when renewing your registration. Option C is both A and B, so if you're renewing your registration later than 30 days of the event, and option D is unsure. So once again, that poll should be coming up on your screen, and we'll give you some time to put through your responses, and then we'll come back and share the results with everyone. And I will just mention again, if the poll hasn't popped up, just try to click on that orange icon and that should open it for you. I'll just keep it open for a few more seconds just to give you a chance to put through any other responses. Okay, we're going to close that one now and we'll share those results. They should come up fairly soon. And thanks everyone for participating. Deborah, I'll hand back to you so that you can go over the responses there and what the correct answer is.
Yeah, great response, Frank. Thank you, everybody. The answer, which most of you got, was actually both A and B. So you need to let the TPB know within 30 days of the event, and also when renewing your registration if it is later than 30 days after the event. So good on you for getting that. Right, so back to the presentation. So as we just said, you must notify the TPB in writing if any of those events that we just discussed occur to you, yeah. And you must notify us within 30 days of the day on which you become or ought to have become aware that the event occurred. So we do have an online form on our website that you can use to notify us about changes in your circumstances, and the form can be accessed via the Contact Us link, which is located at the top of our website. So I think Julie will put a link to that form in the hyperlinks document, so for you to reference. If you are renewing your registration within 30 days of the event, it is sufficient to include the details of the event in your renewal form. However, if the renewal is not due until later, you must complete the online form to notify us of the fit and proper issues. Now, this is not a situation that you can round up all day on days either, so the 30 days is legislated, so you must comply with that. So when you're applying to renew your registration, one of the things that we see is people not mentioning one of these situations in their renewal. And you need to let us know when you're renewing, even though you have told us within 30 days as well. So this needs to be when you are contacting us every single time. So really important that you do that. So who needs to notify us when the changes occur? Individual practitioners need to let us know if any of the events happen to them and if they cease to meet those fit and proper person requirements. If it's a partnership, somebody, a partner or a director, we need to know if they are no longer a fit and proper person. And again, if a company practitioner, one of their directors is no longer a fit and proper person, you need to tell us about that as well. So, the responsibility is very much falling back on you, the individual practitioner, or the partner or the director of the company or partnership, to let us know. In the case of a company or a partnership entity, you need to ensure that there are appropriate mechanisms and procedures in place as part of your internal governance framework to detect and deal with conduct issues of a director or partner. If you're unsure whether a particular conduct or an event affects the fitness and propriety, the individual, the company or the partnership must still disclose the relevant circumstances, and it's up to the board to make a determination. One of the things that I do see on some of our board committee is, practitioners saying, we didn't think you'd be interested in that. We are interested in everything, so fit and proper person is fit and proper person. It's a really big umbrella and fundamental to the integrity of the tax practitioner scheme. So far we have seen who is impacted by fit and proper person requirement, what kind of circumstances or events can impact your fitness and propriety, and what you should do and who should let us know if you are affected by such an event. So now I'm going to go and have a look at how the board will assess fitness and proprietary from the information that you provide or don't provide, and the information that we obtain from external sources or referral sources. So the underlying principle in assessing fitness and proprietary is to protect the community and maintain public confidence in our tax practitioners. It is not to penalise or punish misconduct or unprofessional conduct. So that's a really important fundamental principle that I just wanted to put up front. I'm sure you'll understand when I say there's no set formula. So there's no standard test or rule that we can apply to determine if someone is fit and proper or whether they should remain registered as a fit and proper person. So we consider all the circumstances in the context of the activities that the person was involved in and make an assessment based on all of those circumstances to fitness and proprietary. We believe that we can achieve this ultimate objective by protecting the public, by ensuring that only those who are of good fame, integrity and character and have the appropriate knowledge and skills are registered as tax practitioners with the TPB. So let's look at some fundamental concepts that help assess fitness and proprietary. Some relevant factors that help us to determine fitness and proprietary include conduct that indicates a lack of fitness and proprietary, how a tax practitioner manages their personal tax obligations and that of their related entities, their relationships with clients, TPB and the ATO, previous conduct issues that we may be aware of, and conduct that is not directly related to registration as a tax practitioner. And I'm going to go into each one of those factors in a bit more detail now. So the first one is conduct indicating a lack of fitness and proprietary. And earlier we looked at what we expect of tax practitioners in terms of professional conduct. And to quickly recap, we talked about that this requires tax practitioners to have attributes such as competence, good fame, integrity and character when dealing with clients and regulatory bodies such as the ATO and the TPB. So conduct that falls short of this standard, such that the public or the TPB or the ATO can no longer have confidence that you're performing your role competently and with integrity, could indicate that you are no longer a fit and proper person. Now, certain offences or conducts are so significant that these types of behaviour will render a person not fit and proper. So to give you a few examples, or offences or conduct could include things like conviction for tax evasion, conduct involving fraud or dishonesty, especially those involving client money and payment of taxes, really important. Failure to exercise diligence in ascertaining a client's state of affairs. Failure to take appropriate steps to ensure client confidentiality, and failure to take appropriate steps to protect the integrity of the tax system. So sometimes individual acts or conducts don't appear serious if you view them individually or separately. However, it's possible that collectively several less serious matters or less serious conduct could lead to finding that a person is not a fit and proper person. So it's important for me to highlight here that where the misconduct has persisted over several years or just for a long period of time, it's much more difficult for the person to satisfy a fitness and proprietary requirement. So one of the other factors that we consider when assessing your fitness and proprietary as a tax practitioner is compliance with your own personal tax obligations. And this includes the tax practitioner as an individual, and it includes associated entity obligations. So, you know, for example, if you are the individual, you're a director of a company, the company's tax obligations, if you've got a self-managed super fund, all of those associated entities are one of your obligations. And some of those obligations include timely lodgement and payment of tax obligations. Always surprises me how many tax practitioners say to us, I was so busy doing client work, I didn't do my own. That is not an excuse. Do your own. I always do mine first because I figure I've got all the information, why not? But it is really important to lodge and pay your tax obligations on time every time. Accuracy in completing tax returns and statements, and complying with other requirements of the ATO. So a conduct that indicates a lack of competence could indicate, conduct indicating a lack of compliance can indicate a lack of competence or a lack of integrity and character, and such that we do not trust that a particular tax agent can provide tax agent services to the public adequately. So I'm going to move on to how the relationships with clients, TPB and ATO can affect fitness and proprietary. And one of the things here is a failure by a tax practitioner to properly discharge their responsibilities for their client, and how that can adversely affect their fitness and proprietary. The severity of the conduct is always considered, and it is considered to be greater where the clients involved are in a position of particular vulnerability. And some examples of conduct that could indicate a failure under this concept include things like lacking the knowledge and skills to provide services to a professional and competent standard. And that can be, you know, outside of your specialty. So if you are approached by somebody you know nothing about that and can't get the skills, etc., you don't have the knowledge and skills to provide those services. So it's really important to know when to say no. Failure to prepare or lodge client returns in a timely manner. Failure to respond to client phone calls or emails or letters. Failure to pass on ATO correspondence to clients. And failure to pass on tax refunds or account to clients for the money that is held on their behalf in trust. And of course, there's also corrupt behaviour, such as offering money or other inducements to influence clients against complaining to an official body, such as the TPB. Now, we're going to do a bit of a poll here about looking at behaviours that may indicate a lack of proper conduct when dealing with the TPB. So, Julie, would you like to launch that poll now?
Absolutely. Thanks, Deborah. So that we're just launching that now. And we're having a look here at this poll, and we're asking the types of behaviour that could be considered as not fit and proper when dealing with the TPB. So we've got a few options to choose from, and first one here is failure to respond to TPB's requests for information and directions in a timely, responsible and reasonable manner. Option B is being disrespectful and using abusive language in communicating with the TPB and its officers. Option C, failure to let the TPB know if a staff member who is not a registered tax practitioner or a director or partner is prosecuted for outstanding tax obligations. And option D is providing false or misleading statements to the TPB. And once again, we're going to give you a little hint with this one, and there is more than one correct answer to choose from. So I'm just going to give you some time now to choose your answer, and we'll have a look at that in just a moment. Okay, I'm just going to keep it open for a little bit longer to give everyone an opportunity to put through their responses. Okay, I will close that one off now. Thanks everyone for putting through your choices there. It looks like we've got about 28% of people saying that A is the correct response, about 26 saying B. Sorry, the next one's cut off there. I can't see what that one is, but option D is 29%. So if you do your calculations, you'll be able to work out what C is. But hopefully they're appearing on your screen for you anyway. And Deborah, I'm going to hand back now to you so you can tell us all what the right answer is. Thank you.
No worries. Thank you very much. So the right answer is actually responses A, B, and D. So in general, a lack of cooperation with the TPB and a failure to deal with the TPB appropriately can reflect adversely on a tax practitioner's fitness and propriety. There is a legal obligation imposed on registered tax practitioners in the code to respond to requests from the TPB in a timely, responsible and reasonable manner. And you may recall that is code item number 14. Repeated delays or just ignoring, neglecting to respond to TPB phone calls, emails, letters, correspondence of any kind or directions to provide information, or failing to attend interviews when required may lead to a finding that a tax practitioner is not a fit and proper person. Making misleading or false statements to the TPB, and whether that be on an application form, an annual declaration, a renewal application, or when providing information to the TPB on request. So, for example, if we're conducting an investigation, not giving us the information that's being requested could be sufficient for finding that the tax practitioner is not fit and proper for registration, and also showing disrespect or contempt for the TPB and its officers is also considered conduct that is not consistent with the standards expected of tax practitioners. Now, as with the TPB, failure to deal with the Australian Tax Office and its officers appropriately could also affect fitness and propriety. And some of the examples include things like failure to comply with tax laws, fail to respond to formal notices and directions from the Commissioner, unauthorised access to ATO systems, not cooperating with ATO auditors or officers, and threatening ATO officers as well, which unfortunately I have seen. Now, I mentioned earlier that becoming an undischarged bankrupt is an event that could affect your fitness and propriety. However, it's important to mention here that it is not an automatic disqualification. So the board considers a range of factors when determining if the registration of a tax practitioner who becomes an undischarged bankrupt should be terminated. And everybody's circumstances are different, and so some of the factors that we take into consideration are the conduct or the circumstances that lead to the event, as I said, because not all circumstances are equal. If the practitioner failed or delayed notifying us of their undischarged bankruptcy, if the tax practitioner failed to comply with any statutory requirement that applies to an undischarged bankrupt, in particular under the Bankruptcy Act and Corporations Act. And if there has been an extension of the bankruptcy period as a result of the tax practitioner not cooperating with the trustee or not complying with their obligations under bankruptcy legislation. And finally, if there is any risk to the public. So now let's quickly check the obligations placed on companies and partnerships, and particularly on the directors and partners. So if a director of a company tax practitioner is found to be is found to not be a fit and proper person, the company will no longer be eligible to remain registered, while that director remains a director of that company. So similarly, in the case of a partnership tax practitioner, the partnership will not satisfy the registration requirements if an individual partner or a director of a company partner is found to be a not fit and proper person, and if they remain a partner or a director. So in this case, the company or partnership needs to take steps to have the offending director or the partner removed from the entity if it wants to remain registered. And so while the remaining directors or partners are not held liable for the offending director or partner, if they come to know of the misconduct and they fail to take steps to address the issues, this failure may affect their own fitness and propriety as well. So conduct that's not connected to registration. So a tax practitioner's conduct in the practice of another profession can also be relevant to whether the tax practitioner is fit and proper to obtain or to maintain registration with the TPB. So let's do a quick poll now to get your views on fitness and propriety assessment, where a tax practitioner's conduct is not connected to their professional competency as a tax practitioner. So over to you, Julie.
Thanks, Deborah. So the question we have for you this time is, can a tax practitioner be considered fit and proper if they are competent but exhibit an abusive behaviour towards their staff? So we've got three options there. One is yes, then we have no, and then we also have depends on the circumstances. So we'll give you some time to put through your responses there, and then we'll come back. Okay, we'll keep it open for a little bit longer. Okay, thanks everyone for putting through your choices there. We'll just close that one off. And Deborah, it looks like we've got about 8% of people saying yes, 51 saying no, and about 41 saying it depends on the circumstances. So I'll hand back to you and you can let us know what the correct answer is. Thank you.
That's good. The correct answer is in fact B, no. So we do not consider that to be professional fit and proper type conduct, to be abusive towards staff, and so that is considered not fit and proper. So still on conduct that's not connected to your registration. So a person or employer's behaviour towards their staff is equally as important as that to their clients, regardless of the type of profession that they may be in. So even though a tax practitioner may be extremely competent, bad behaviour towards their own staff will impact adversely on their fitness and propriety, as it undermines the reputation and standards of the profession as a whole. So this applies to any conduct that is closely connected with the practice of a tax practitioner. Another common scenario we see is where a tax practitioner has been banned or sanctioned by another regulator, so for example ASIC, and we also take that into consideration as well. So far we've seen a lot of factors that could lead to a person being found not fit and proper. Let's see if there are any other circumstances that the TPB takes into consideration where a person has engaged in misconduct or wrongdoing. As I mentioned earlier, the underlying principle in assessing fitness and propriety is to protect the community and to maintain public confidence in our tax practitioners. It is not to penalise or punish misconduct or unprofessional conduct. So a tax practitioner who engages in misconduct or wrongdoing may still be considered fit and proper where the tax practitioner has displayed genuine remorse, contrition, and understands the significance and consequences of the misconduct, and or take steps to mitigate the circumstances. In these instances, it's possible that the board may have the confidence in the tax practitioner's continued ability to honestly and competently perform their duties. We also take into account things like our tax practitioner's level of frankness and their cooperation with us, the TPB or the ATO, when confronted with their misconduct or unprofessional conduct. Now, let's quickly cover what the consequences might be if a tax practitioner or a director or partner is found to be not fit and proper. So, firstly, if an individual tax practitioner is found to be not fit and proper, the board may terminate their registration as the individual ceases to meet a registration requirement. So if a director or a partner is found to be not fit and proper, the board may require the company or the partnership by written notice to have the offending director or partner removed from the entity. Failure to comply with the notice to remove the offending director or partner may be considered a breach of the code in itself, and it could result in termination of the company or the partnership's registration. And in the case of a sole director company, the board would terminate the company's registration as well, as the company will cease to meet the registration requirement that each director is a fit and proper person. So, of course, termination of registration is an appellable decision. So if a tax practitioner does not agree with the decision that has been made by the TPB, they have the right of review with the Administrative Appeals Tribunal. Now, everyone loves a good case study where we get to see, how this is actually put in real life. So let's have a look at some real life case studies to show how what we've actually seen and done in the past. So the first one I've got is, in this case, investigations showed that a tax agent had made false statements in many of their annual declarations and in their application for registration renewal. They declared that they did not have any outstanding personal tax obligations, when in fact they had outstanding tax returns and outstanding tax debts. Now, when we say outstanding tax returns, that can be tax or BAS returns, and they are treated separately. The tax agent is also provided false and misleading responses when we made inquiries about their working relationship with two other tax agents, or ex-tax agents, I should say, that had their registration terminated. And we also found that the tax agent had allowed the use of their tax agent registration number and ATO portal access. They'd given it to a deregistered agent to enable the entity to provide tax agent services to clients, and failed to provide adequate supervision and control. So I think that's a really big one as well. If somebody asks you to lodge on their behalf, beware. And further, it was found that the deregistered tax agent had also amended BAS and reported incorrect amounts for a client in order to obtain cash flow boost payments from the ATO that the client was not entitled to receive. And in this particular situation, in this one, the Board Conduct Committee, or the BCC, I'll call it, found that the tax agent breached the code in that they made false statements to the TPB. They were not meeting their personal tax obligations. They were not providing a competent service, and they knowingly obstructed proper administration of tax laws by enabling a deregistered agent to use their portal access and lodge an amended BAS without adequate supervision and control. So the Board Conduct Committee also found that the tax agent's conduct was serious and deliberate, and they demonstrated a lack of integrity and a disregard for their professional and ethical obligations under the Code and other tax laws. So the BCC determined tax agent was no longer a fit and proper person to be registered, and that tax agent's registration was terminated and a 4-year ban was imposed on them. And it's worth noting here that even when you come back in to the tax system, it might be 4 years that you're banned, but when you come back, you need to now show that you are now a fit and proper person. So that can, have its own challenges. In the second case study, we've got, it was a referral. It was from the ATO, and they asked us to investigate the conduct of a sole director company tax agent. And the tax agent had transferred clients' tax refunds to bank accounts that the agent controlled without the knowledge or authority of the clients. The company accepted ATO refunds on behalf of the clients for returns it didn't lodge, and then failed to return the refunds to the ATO or pass them on to the relevant clients. So additionally, the funds were then used to pay for private expenses. The tax agent also failed to declare outstanding tax obligations of a related entity in its registration renewal application, and I mentioned that earlier, that it is individual and your related entities. So if you're a director or a partner of any other entity or a trustee. The tax agent also failed to respond to the TPB's inquiries in a timely, responsible and reasonable manner on several occasions. And one of the things that does surprise me is the amount of people that just don't respond to the TPB when we are doing an investigation. And the BCC determined that the company's conduct was serious and deliberate and showed little regard for professional and ethical obligations as a registered tax practitioner. So the sole director, being the person responsible for the company's conduct, was also found to be no longer a fit and proper person. And so as a result, the company's tax agent registration was terminated by the BCC, as was the directors. Case study 3, we have a BAS agent registration had been terminated after we found that they had breached multiple obligations under the code. So our investigations found that a BAS agent had made false and misleading statements when lodging registration renewal applications and annual declarations to the TPB. They had recorded details of professional indemnity insurance cover that they did not hold. They submitted a false medical report, and they failed to show that they had completed CPE that met the TPB's requirements. And hello, Chanel, you need to behave, sweetheart. And they displayed a high level of disrespect to the TPB and our officers by using derogatory, obscene and abusive language in email correspondence and telephone conversations. So in this case, the BCC considered that the BAS agent's conduct was serious and demonstrated a lack of regard for their professional obligations, and we could not trust that the BAS agent could perform their functions with integrity. So the BCC determined that the BAS agent ceased to be a fit and proper person and therefore failed to meet a registration requirement. The BAS agent also failed to meet the registration requirement of having professional indemnity insurance that meets the TPB's requirements. And so the BCC terminated the BAS agent's registration and prohibited the BAS agent from reapplying for registration for a period of 12 months. I mentioned earlier that if a practitioner is not happy with a finding of the boards, they can appeal to the Administrative Appeals Tribunal. So here I've got a case study where an agent took it to the AAT. And this is a classic case where it shows that a registered practitioner's compliance with their own tax obligations is necessary in upholding public confidence and trust in the profession. So we've got Mr. Alan Goad. He's a tax practitioner in Queensland, and he was also a director of a company practitioner as well, and failed to comply with his tax obligations and TPB orders to bring those obligations up to date. So in this case, it was particularly significant because there were several outstanding lodgements that had accrued over an extended period of time, and Mr. Goff had failed to take steps to comply with the TPB's orders when they were imposed. So further, Mr. Goff failed to comply with another order. The TPB had ordered him to complete a course of education and to provide evidence of that completion to the TPB. So when Mr. Goff took it to the AAT found that Mr. Goff's conduct demonstrated a deficiency in integrity and character and did not lead by example in meeting personal tax obligations in a timely manner. The AAT further noted that Mr. Goff did not demonstrate any genuine contrition or remorse in relation to the misconduct, and Mr. Goff was given every opportunity to remedy these defaults, but he failed to do so. The AAT found that it could not be satisfied that Mr. Goff was a fit and proper person, and whether he should be and should not be registered as a tax agent. So the AAT affirmed the TPB's decision to terminate Mr. Goff's tax agent registrations. So as you can see, there's a variety of behaviour. There's no one set formula for fitness and propriety. And it can be tricky, and sometimes it can be obvious, as you can see in some of those cases. You just go, of course, but sometimes it's not always clear cut. So anyway, that brings us to the end of today's presentation. I do hope that you found some of this information helpful, and thank you for joining in and also for participating in the polls. It just makes sure we keep everyone awake. And Julie, have we got any questions?
We sure do. We've been busy in the chat box. I'll try to squeeze in a few for you, Deborah, before we sign off. But the first one I want to ask, we had a couple of people asking this one. In the webinar, you spoke about complying with personal tax obligations quite a bit. But if someone has a payment plan in place with the ATO, do they need to disclose the payment plan arrangements in the registration renewal with the TPB?
Yep, great question. Yes, you do need to disclose any outstanding tax obligations, such as a debt, in your registration renewal, and if it's under a payment plan or not under a payment plan. So importantly, as I've mentioned a couple of times in this, and I can't mention it enough because so many people get it wrong, that it extends to your company or partnership obligations, self-managed super fund, trusts, anything where you are an associate of that. You need to make sure that your tax obligations are up to date. So that includes your personal tax, personal BASs, your personal tax returns, practice tax obligations, and again, just any entities that you have control over. So, and also, as you asked in that question, even if it is under a payment plan, you still need to disclose that to us in your renewals or annual declarations.
Thanks, Deborah. The next question we've had a bit as well in varying iterations, but the question I'll ask you now is, why are people allowed to practice after offending? Surely they will go ahead and do the same thing again.
Yeah. We do apply a graduated level of administrative sanctions where the behaviour is particularly egregious, and sometimes it's long periods of the behaviour, we do make the decision to terminate a tax practitioner's registration, and we can also determine a period of no more than 5 years, which they cannot apply for re-registration. So that's actually, as per the TASA, they're the powers that we have under the TASA to do that. The primary purpose of imposing a non-application period or sanctioning someone is to protect the public and the integrity of the tax profession. So, we do keep terminations for, the serious behaviours. Sometimes, we don't want to be terminating somebody for making a mistake. If somebody has made a genuine mistake, for example, we might give them an education order or something like that. So it is a graduated level of administrative sanctions and a webinar all on its own.
Thanks, Deborah. I might just squeeze in one last question before we finish up. And this one is around extenuating circumstances. So are you able to tell us, are there any extenuating circumstances that are considered in relation to fitness and proprietary?
Look, there's no, as I've sort of alluded to in this webinar, there's no set formula for fitness and proprietary. I mean, there are some components of it that might seem black and white, but there's also a whole bunch of components that aren't. So we do treat each individual practitioner's circumstances individually, I guess. We look at all the circumstances. We look at, what they did. Was there a why they did it, if we can. What have they done since? Have they tried to fix the situation in any way, shape or form? All of those types of things. So although we don't have a list of extenuating circumstances, we do take all circumstances into consideration, including health, all of those types of situations. So, yeah.
Yeah, it's good to know. Thanks, Deborah, because we did have a couple of people curious as to, why sanctions were a certain way, but I think that comes back to that, and I think you've answered that for us today. Thank you so much for that. So I think that's all the time we have for questions today. We have gone a little bit over. I apologise for that, but I thought it was important to get those questions in today. So Deborah, I just wanted to say thank you to you for that wonderful presentation. It was really helpful. Thank you so much for your time today and your expertise. It was great to hear from you once again. And I just wanted to encourage everyone to stay in touch with us so that you're keeping up to date with all the latest information. You can do that by following us on LinkedIn, Facebook and Twitter. You can also subscribe to our TPB e-news, which is our monthly newsletter. If you don't already, you can do that at tpb.gov.au/newsroom. And if you are interested in attending more webinars, you can jump on our website and register for those at tpb.gov.au/webinars. And we'll have all this information in our hyperlink documents if you don't get that down at the moment. And also, just finally, you can subscribe to our YouTube channel as well. We do record all of our webinars, and we've got a comprehensive library of webinars available for you to watch there. And if you didn't watch our CPE webinar this morning, you may not know that you can still claim CPE for viewing the recordings of our webinars as well. So that's really good to know. And then finally, to finish up today, I just wanted to also say thank you to Fiona and Daniel for assisting with the questions today. Thank you so much there, guys, for your help. And we do hope that everyone who was online with us today did enjoy the webinar and found it beneficial. They're a great way to keep up to date. So yes, just to finish up, we will be launching an exit survey, and we would appreciate it if you could take the time to complete it. It is really quick and only takes a moment, but it gives us some valuable feedback in terms of how we can improve on what we're doing. And also, if there's any topics that you want to hear from us about, just let us know in that survey as well, and we'll endeavour to put something on for you there too. So the survey is just going to pop up in your browser once you leave the webinar. So once again, thanks everyone for joining us, and we hope that you enjoy the rest of your day. We'll talk to you soon. Bye.